What's better than earning money from a 9-to-5 job? It's earning money while you sleep, which is made possible if you start investing. You're listening to the Real Estate Investing Demystified with your very own dynamic duo, Ava Benesocky and August Biniaz. Tune in as we discuss everything real estate, both on the passive and active sides. We feature life-changing stories of today's real estate leaders that will help build your own roadmap to success. This is a show that will lead you to a diversified portfolio, a much bigger revenue, and a next-level venture that brings you a smooth cash flow. Let's get this episode started. Welcome back to Real Estate Investing Demystified. We're really excited about this episode today.
We are. We can't keep saying that. We can't keep saying we're super excited, but we are excited. You know why we're excited? Because, today is November 2nd, 2023.
Yeah.
We're going to try to publish this show as soon as we can. The Fed had a meeting today and they decided not to increase rates, but they have increased rates now, I believe, 12 times, right? One of the fastest pace ever in history. And I would, my analogy in Fed raising rates is, and what effects it has on the economy is, as the economy was a bodybuilder, and the interest rates are a squat rack, the weight on the shoulder of the economy.
Okay, nice.
And as the Fed increases rates, the Fed is slapping more plates on that. So the economy is trying to get up and do squats, and it's going to make it more difficult every time. So the fact that they didn't increase rates, it doesn't mean the weight came down. The weight's still on the shoulders of the economy. So, now using that kind of as a foundation of our conversation, and especially with our guest today, we saw this coming. We haven't done a deal in 18 months, and that's right, terribly hard on our company because of so much overhead costs that we have, but we haven't done a deal in 18 months.
And we constantly communicated with investors why we're not doing a deal, because there's investors coming through the funnel constantly. Where's the deal? I have money to deploy. And we just told them, listen, we're patiently waiting on the sideline. We're not going to be doing any deals.
And we almost
follow us along the journey.
We almost feel vindicated now that there's so much distress, not only as far as smaller and newer syndicators, we're talking about institutions. These are large firms that have a larger analyst team than our whole company. And they're finding themselves in trouble.
Yeah.
And the question is, you always hear about syndicators or institutions going into foreclosure or default. People understand what happens on the single family side, but what happens on the institutional level? What happens when you have a $50 million property that goes into foreclosure? What takes place? Who helps you there? What happens? What options do you have? What remedies do you have, both for LPs and GPs? And we believe our guest today is going to decipher many of that, or as we like to call it, demystify, as is the name of our show.
Yes.
And we're excited about that.
It's truly unbelievable what's happening. And investors are now, I'm talking to investors every single day since we started our company, but tons of investors. And they're saying, good job, guys. Good job not buying any deals. Because what we're seeing today with the distress that's coming to the market, we're going into a tremendous buying opportunity. We feel like we're in a great position in our company here. So we're excited to move forward into 2024 and discuss all that.
We're going to discuss that with our guest as well. But you can see the stress coming to the market every day. The deal in Houston that the syndicator lost $200 million of assets and lost all the LP equity. So,
we actually have been submitting LOIs, underwriting properties like crazy here in Jacksonville and Tampa. We love the Florida market, and by the time we actually got accepted on a deal, there was 5 distress properties that came across our desk.
That's right.
And we looked at each other and we said, you know what, let's not move forward with it. We decided not to go ahead with that particular deal, but we're excited to see what happens moving forward.
Okay.
So let's get into the meat and bones of today, you guys. Yes. Today we have a guest who is an expert in this space of distress, and we're hoping to get a crash course on what happens when deals go sideways. So let me introduce our guest. His name is Leo Jacobs. Okay, Leo is a commercial litigation and bankruptcy attorney and the founder of Jacobs PC, a boutique law firm known for finding creative, direct, and expedient solutions to complex and high-profile issues. So we believe this interview with Leo will bring great value to both limited partners and general partners to learn about the nuances of foreclosure and remedies which exist in this space. Leo, welcome to the show. We're so happy to have you.
How are you? Good afternoon. It's a pleasure to be here. It's wonderful to hear you. I've been listening to you guys for some time, and I'm excited to share all of the knowledge of what our team at Jacobs PC has to offer. So please, I'm your guest. Thank you so much, and I'm looking forward to our time together.
Likewise, Leo.
Thank you.
Maybe before we get into discussions, could you tell us what interested you in this type of law you practice? Sometimes attorneys have a great story on why they got into a certain type of law. For example, there was a guy we watched on YouTube, and he got into law because his father was ripped off in business. And that's why he became a lawyer.
Oh yeah, or stories about movies like Reuben Hurricane Carter, what happened with him, and Lazar Martin, who became an attorney as a result of that story, and they vindicated him and what have you. So you hear always these different stories, lawyers have for becoming. Tell us about what was
your why, Leo?
So my inspiration was that I actually wanted to become a doctor before I wanted to become a lawyer. And it really derived out of the passion to help others. And I realized very early on in my life that what I was born with was the ability to carry great weight on behalf of either patients or clients that would follow along my advice. As you may now understand, I didn't become a doctor because I just really wasn't good with blood. And I became an attorney because I thought that the ever want to help someone was as transferable in being a doctor to being an attorney. Actually, my want and desire to become an attorney was doubled down when I began representing debtors. And representing debtors, you have to be a specific type of counsel. So I always say that I'm inspired by the name of attorney and counselor at law, attorney being an advocate, a counselor being someone that sits with the client and actually takes them through the divisions of their problems. So, what inspired me to become an attorney? It's my invariable need to help others, okay, in a very specific way. To very specific clientele. And I found that type of aid is important for the debtors that are currently the debtors in this environment, and currently those that are becoming the debtors in this environment, who may have been the creditor, and et cetera, et cetera. So it comes out of the need to help.
So it wasn't any particular circumstance in your life or a situation that took place. It was broadly trying to help people, and then you found your way. You're a perfect son. So doctor, lawyer, you can either be a doctor or a lawyer, and he became a lawyer. So there you go. So yeah, before getting into the mechanics of foreclosure and kind of going over everything, let's kind of break this down a bit, and for our viewers and listeners to understand it as well. Let's differentiate between a absolute fraud or a Ponzi, a scheme that's put together to rip investors off or partners off, or negligence and or also incompetence, right? We're seeing, in our space, we've seen all three of those. We're involved in some situations that, Ava is going to get to this in a moment, that others are being very aggressive. So before touching on that, could you differentiate between those three different situations?
Absolutely. So we actually, our office, it's extremely interesting that you asked that. We have in our office here a specific case that regards a ticket reseller. It's in the bankruptcy court now. I'll take you through it a little bit about what happened, what the procedural posture is. It's an overwhelmingly interesting case. It happened back in 2019, still currently a case right now. So let me tell you the macro background really quickly for you to understand. So I'll back into the question of Ponzi scheme. There was a ticket reseller for major events, tennis, Met Gala, and this is all over the world, okay? All over the world. All types of tickets, basketball, royal events. And this mathematician, we'll call him a mathematician. This mathematician thought of a business plan. He said to himself, why don't I, right, like Ticketmaster, begin buying these tickets in bulk, okay? So he began buying these tickets in bulk. And what happened was his burn rate, right, which is called carrying cost, got really, really high. But he was selling the tickets also really, really quickly. The part where he messed up in was he failed to project certain specific events in the market that would slow the value of those tickets and slow how quickly those tickets are sold. That's called a business judgment, right? So in any case, you have what's called a business judgment. It's called a business judgment rule. And your judgment could be arbitrary, it could be unfair, right? But it can't be fraudulent, right? It cannot be fraudulent. And that's what you're talking about. You're talking about negligence, you're talking about recklessness, you're talking about intention, you're talking about fraud, all right? Those are very specific concepts, and I'll break them down. So continuing our story. He began not being able to sell those tickets as quickly, okay? But he took on people's dollars in the form of debt and in the form of equity and in the form of debt that may be converted into equity. And we're talking about $200 million. We're not talking about $5 million, right? So I kind of left that bomb in the middle of the story, right? So this is a very large scale operation, all right? So unfortunately, he committed fraud, okay? He has since taken the plea and has gone to jail, okay? He took a plea because they got him on a recording. They would be his main investors that invested debt to be converted into equity. In the event he sells all, say, 100 million tickets, he makes $1 billion. He gives, they'll convert their debt into equity. Once they convert their debt into equity, the equity is obviously worth greater. But what he did was, which was fraud, is he literally photoshopped his numbers every month, okay? That was the actual fraud. This person, we don't represent this person. We represent people that gave him money, okay? We represent one of the biggest net winners that invested millions and millions of dollars into this individual. So what happens is now he admits to the wrongdoing, okay? He admits to the wrongdoing, and now there are a set of creditors that are waiting to be paid, right? There are a set of creditors that is waiting to be paid. And these creditors are now infighting with each other because they're saying, hey, I'm first. No, I'm first. No, I'm first. No, I'm first. No, I have to get paid first. I have to get paid first, right? So we have what's called a priority fight, right? So there's no multiple creditors. There's a priority fight. Now, there has to be a forum, right? An arena where this fight occurs. So what happens is, in the event that you can prove somebody was concocting a fraud, you are able to move in the state court for what's called a receiver. And that's what happened. And you're able to call for an attachment of that person's asset, both corporate and personal, to stop, right? To stop dead in its tracks any sale of boats, Ferraris, houses, buildings that person might have, to take that money and run, to Australia, or Thailand, or whatever, Cuba, the United States and Ohio, whatever he wants to go. And the firm was, I think, Morrison Cohen, that they're an excellent firm. We're oftentimes their adversaries, excellent firm. They moved for an attachment successfully. They moved for a receivership successfully. They appointed a receiver. They attached the assets, okay? And now they plunged it into bankruptcy, okay? So take a chicken with flour on it and some egg yolk, and you drop it into the frying pan, right? And it just like blows up, right? Pardon the imagery. But now he's fried is basically the point. And now what happens is the receiver goes away and a trustee is appointed in the bankruptcy arena. You're in the bankruptcy arena. You have the creditors that lined up. And now what happens? Now what happens? The creditors are sitting there and they're like, look, we're real creditors. We have a real UCC lien. We have placed a UCC lien. We have perfected ourselves properly. Everybody else, this is the magic trick. Now I'm answering your question. We need to kick out 10 of these creditors with an aggregate amount of $50 million. And if we kick them out, we get to keep that $50 million. Mm-hmm. And the trustee is like, you know what, guys? I'm going to kick all of you guys out and I'm going to keep the money if I can prove, and here's the magic question, if I can prove that it was a Ponzi scheme. Now we get to the question of what is a Ponzi scheme and how do you prove it? A quintessential Ponzi scheme is when you take the dollar of one and give that same dollar to another and say, I've made a return where there was no quantifiable product or service that is created, or the level of investment equal to the output, right? You take $1 billion, you make 2 eggs, right? And you keep the rest for yourself. That's essentially called a Ponzi scheme, okay? So how did the creditors think of this? They said, look, this guy wasn't really buying enough tickets. This guy wasn't really buying tickets at all. He just used it for himself and bought himself Ferraris, planes, women, wife, drugs, booze, whatever it is that he did. And now there is a big brief that is due in front of the bankruptcy court to answer the question about whether the dollars of our client that were given and the dollars that were given by other clients that have received their investments back already, would they have to give it back? Why would they have to give it back? Because that means that the client that I'm representing has the money that is not the mathematician's money. It's the money of that other investor who's an actual investor or an actual creditor. I hope I'm not losing you, but I'm trying to explain it as best as I can.
Yep, you're doing a good job.
If we answer the question that the mathematician is not a Ponzi scheme, which from my point of view of my client, we don't want it to be a Ponzi scheme, because if it is, we're giving back the money, right? But if it's not a Ponzi scheme, and we have reason to believe that it's not a Ponzi scheme, it falls within the Ponzi scheme exception, right? Which is not taking the money and giving back it to the investors. Aside from the fraud that was concocted, the fraud that was concocted was that he photoshopped the numbers, which is not in and of itself going to prove a Ponzi scheme. What it proves is just general fraud. What is general fraud? There's 2 types of fraud. There's false pretense and there's fraud in the inducement. Fraud in the inducement and false pretense, before I get into them, I will explain in a moment. I'll finish the Ponzi scheme exception. So put that in the back of your heads. So the Ponzi scheme exception is taking the dollar of one and giving it to another without any value or service that's created. Obviously, this is an oversimplification of the Ponzi scheme for the purposes of our video today. But if anybody wants to get a pristine, shot-to-shot elements of them, I'm happy to obviously tell them. But the oversimplification is $1 for $1, the same dollar, not a different dollar, the same dollar, and no value or service that is actually created, or very little in the amount that's actually put it in. That's a Ponzi scheme. But our client is saying it's not a Ponzi scheme because he actually took our money, although it was on 24%, 25%, 18%, 15%, 1%, and he gave us that money back with our interest, not using the money that was given from somebody else, but from the value of the services that was created. So now the trustee has to divide. Can you imagine dividing? How do you know what dollar was from a Ponzi scheme and what portion of the dollar was not a Ponzi scheme? It's an almost impossible feat. So there's a lot of research analysis that needs to be conducted in order to determine that question. Now, I'm pretty sure I answered your Ponzi scheme question. Let me answer your negligence, recklessness, and intention. And let's go through negligence. Negligence is you are not aware of and you can't consciously disregard something. For example, you're driving, right? You're driving and you hit somebody and it's an accident, right? Not whether you were drunk, because that could be a different thing, but whether you weren't paying attention or the sun was in your eye, that's negligence, right? You weren't aware of and you couldn't consciously disregard. Recklessness is green light, red light. You are consciously aware of it, and you're consciously aware and you consciously disregard it, right? That's already recklessness. Aware of, consciously disregard. There's intention. The intention is you guys are racing down the street. You see there's the green light. Your intention is to run through that red light. That's intention. And every one of them holds a higher degree of punishment, whether it be civilly or whether it be criminally. Right now, we're talking about civilly. There's civil punishment and there's criminal punishment. We deal with the civil punishment, and we have outside counsel that handles our criminal affairs as well. So that's the answer to your negligence, recklessness, and intention question, right?
There's different degrees there. There's different degrees there. Allow for Ava just ask this quick questions because I think this is going to play into perfectly here. So
okay. Yeah, okay. Sounds good. Yeah, Leo, another follow-up question on this is LP in most cases have to sign a lengthy, like 200-page document. It's called the private placement memorandum, which outlines many risks associated with the deal. Now, explain to us, if the GP loses all the LP equity due to incompetence, but not fraud, are they legally sheltered, even if they took unreasonable risks? And the reason why we ask this is very important is because today deals are not really they're not making sense. They're not penciling out is what we say. But there are groups that are syndicating deals and they're being extremely aggressive on their exit cap rates or their rent growth that they're predicting.
We're assuming that we're taking a deal, we're underwriting a deal, and it's coming back at 15% average annualized returns on our underwriting. And we're doing everything pretty industry standard. And we're seeing another team buying it for 10% more than we paid. And when we put that number into our underwriting, their returns come back at single digits, right?
8%, right? And so is this considered just business, or does this fall under fraud? Because the way we look at it is when they go out there and they're saying, I'm going to get you 20% average annualized returns, but we know internally with our sophisticated
that's impossible.
It's impossible. What does this fall under?
Okay. So for all intents and purposes, we're going to take this as a hypothetical, because I can't give legal advice on a show to both of you. We'll take it as a hypothetical. Okay?
Yes. Okay, perfect.
Harry and Jane have an investment fund, and they have a bunch of LPs. Okay, and we'll blur the facts a little bit, and they have an investment that they have created. It's an investment vehicle with a projected return that is annualized for the market, okay? And in their private placement memorandums, okay, probably a 506 A or B.
C, yes.
Forgive me.
Yes.
Thank you for reminding me. I appreciate that.
Okay.
They go and solicit the investors that make the available amount every quarter or every year. And 10 investors come back and they all sign up. And in there is what will be called a warning notice about securities, right? They're private, they're volatile, they might crash, there's no guarantee, market could cancel itself. Now, there's a business judgment rule that I was discussing. That business judgment rule can be arbitrary, okay? You can promise people the world, and if it doesn't work out, as long as those people were on notice that it's not going to work out. For example, there's an oil refinery in Africa. It's going to be a big deal. We're going to be billionaires. This is the analyzed return if it works. But, sir, if it doesn't work, you're going to lose all your money, and that's a problem. And the person's like, okay, I understand. You've told me what those returns are. You told me how they're possible. So first thing is first, before you get to fraud is really reliance, right? It's an estimation of a present fact that you know. And I'll make it very, very simple, okay? Someone comes into your house for a piece of apple pie, okay? And, you don't really like this person. So you begin to tease him and say, hey, I'll give you a piece of apple pie if you clean my bedroom, or you clean my room. And you don't really have apple pie. You have pecan pie, and the person's allergic to pecan. And you know that he's allergic to pecan, or she's allergic to pecan. But you're like, listen, don't worry, I got apple pie in the fridge. There's what's called reliance on a current fact, right? Not a fact of the future, but of a current fact that is not true. So what did you do? You made the person agreed relying on a current fact that is false. So when she cleans the room, you give her a pecan pie. And what does she say? I've been bamboozled. You've concocted a fraud against me. And you're like, no, it's cake. And you're like, but you promised me apple cake. I have pecan pie cake. Well, I'm allergic to pecan. Give me my money. Give me money. I need to punish you for two reasons. One, you need to pay me for the value of my services. On interest, it took me 2 hours. And two, I need to punish you so you'll never do that again to anybody else. Did you understand what fraud means?
Yes.
Fraud means it's a current fact. So getting back to your example, you said, I've annualized the return, right? I've annualized the return, Leo, and it's single digits. How could anybody else promise double digits? How could they not promise single digits? It has to be an actual current fact. And fact is very tough to prove now, isn't it? Because everybody has different opinions now, don't they? So it's a little bit more sophisticated, and that's why we're using a hypothetical, right? We don't want to get into legal advice. We want to introduce the concept of what fraud means. And fraud in the inducement is just that. Based on a material fact that was untrue, I was induced to do something that wasn't actually true. And that's where fraud comes in. It's a feeling of bamboozle, right? It's not a feeling of, oh, the market went sour, or, the market has failed and we've promised these returns that they didn't promise. Now, that is not to say that somebody's not still going to sue you. They might sue you for all other reasons other than fraud, because fraud is a very high standard. And when I speak about fraud, I speak about it generally as a New York attorney, okay? There is the uniform fraud statute. It has been adopted in many, many states. I think New York has adopted portions of it, fraudulent conveyances, so on and so forth, which I will not talk about today. But to be on point for just a little bit, you want to make sure that in your documents, you are dictating current present market conditions, and your projections are based on current facts that are objective. Does that make sense? Yeah. So if I'm projecting 50% returns based on my apple pies, which are really pecan pies, that's no good. You can't tell somebody we're going to give you an annualized return of 50% when half of your workforce already quit. You can't be promising that, because as a matter of fact, that your projection is not true. Right. Do you follow what I'm saying? So that is what people have to, I guess, rely on when they're talking about fraud. Fraud is also a particular standard under the CPR in New York. It cannot be pleadings have a liberal standard. When you're doing a summons and complaint against somebody, they have a liberal standard. Here, when you're doing fraud, it has a particularity standard. You have to give the time, the place, what was said, how it was said, to whom it was said, who heard it, to understand, for the judge to say, this case should not be dismissed. Also, it is routinely dismissed. We have a case right now. It is routinely dismissed when someone says, oh, yeah, the investment's good. It's good. It's going to be great. Amazing. That's called future performance. You cannot guarantee future performance. Let me ask the both of you. Do you guys have a crystal ball to say whether your investments are going to work out?
We wish we did.
Yeah, that's right.
So wishing is what we are all doing with the advent of our analysts, our genies, our lawyers, our own intuition, right? But you can't guarantee future performance. And I'm sure you say that in your documents, right? Yeah. So we took care of fraud. We took care of negligence. Let's talk about business judgment. You take the fund, right? And you go buy 15 multifamilies at your annualized projection. COVID hits, rent loss change, interest rates go up. You have the LPs knocking on your door, and they're like, you messed up my stuff. You should have known better. You should have been smarter. I paid you. I trusted you, right? What they're saying is, I invested into your judgment of your business, and I'm going to sue you to measure, right? To measure whether you've committed what's called gross negligence. Okay? What is gross negligence, right? Gross negligence is called outside the parameters of a business judgment rule. Okay? That means that you can have arbitrary decisions. You can have unfair decisions. It's within the business judgment. It's extremely wide. And again, I'm speaking about New York. Other laws could be different. Other states could be different. Just giving you kind of like a disclaimer, if you will. And that is going to be tested by a court of law, unless you come to some type of an agreement, right? So if you're getting phone calls from LPs saying, can I get an accountant? Can I understand what you did with the properties, or the investments? Yes, that can be done. But just because you lost the money doesn't mean you've strayed away from your business judgment, committed negligence, or committed fraud. And that's all I'm going to say. I could talk forever.
Got it.
Whatever follow-up questions you have, that's kind of the big bubbles.
We appreciate it. Let's kind of get into the kind of main milestones of a case. Like talk about foreclosure. So we were watching one of the shows you were speaking on, and you talk about a lot of clients that you currently represent who are debtors, basically, right? They owe to a lender. And we want to understand kind of the step-by-step milestones. So if it's a syndication group, if it's a private investor, they bought a piece of property, their business plan didn't go as planned, their rents didn't grow the way they were hoping, the rents actually were in negative territory, they had some issues with renovations, and now they're having a hard time, and interest rates went up, and let's say their rate cap expired or something happened, and now their debt service is so high, they can't pay their mortgage payment. So talk to us about kind of step by step, and let's say this investor is very astute.
Do you want the vantage point of a lender, the debtor, the LP, the GP, or do you want to talk about everybody? Because I can talk about everybody.
Yeah. No, we want to talk about yourself. So let's say this investor is very astute and they brought you in early on. So they give you a call, say, hey, listen, Leo, we're in a bad situation here. We're looking at what we have in reserves. We see how much money we have. We see what is our burn rate. We're not going to make it. So they call you right there. Talk to us step by step what happens and where you come in, and then maybe talk about you're a master at bankruptcy, but a lot of people think about bankruptcy and they think about personal bankruptcy or what have you, but there's different ways of bankruptcy for an entity like an LLC. Talk to us step by step when you get that call, what happens and what takes place and what's the best case scenario that happens, and maybe touch on LPs as well, because you're trying to save the syndicators, but the sponsors, but what happens with the LP equity? Is there any way to save some of that too?
Excellent. Okay. So here's what we're going to do. Okay. We're going to create another hypothetical. All right. The hypothetical is going to be Barney's GP investment fund that has, 5 big burdens in it. Okay. The big birds are going to be the LPs and Barney is going to be the GP. Okay. Just to kind of make it easier for everybody to understand. It's crazy enough of an example that nobody's going to forget about a purple dinosaur. All so right. Barney is the sponsor. He has these LPs, which are all the big birds. They're big yellow birds. And they're going to go and purchase 15 Barney homes, okay? 15 Barney homes. They're big purple homes. And each of them was $10 million because they want to build the Walt Disney of Barney, okay? And what happens is COVID happens, rent loss change, interest rates go up, and the reserves are dwindling down. Now, Barney's sitting there and he's like, oh my God, what do I do? I got to call somebody. And he calls Leo Jacobs, and he's like, Leo, the LPs are knocking at my door. I can't really pay the returns anymore. Rent loss change, interest rates are up. What do I do? The first thing that you need to do is you need to really take a deep breath. Okay, because you're about to get into what I like to call the tease period. Okay, it's a tease out of the relationship between the aggressor, which will be the lender, okay, and the prey, which in this case would be Barney. Okay, and Barney wants to be as far away as possible from the lender's actions to recapture its collateral, right? But that does not mean that he can't have a dialogue with the aggressor, which is the lender. So the first thing that Barney did correctly is he stopped talking to the lender. He stopped talking to the lender's lawyer, right? And he hired Leo Jacobs, which sometimes could be a hostage negotiator, right? You have the asset, right? You have the gun to the person, right? Or you could be someone that is more astute, like 007, right? And having a card game and a poker game. Hey, what card you got? I got this thing. I got a nice kicker. What are you going to do, right? So I'm making this as fun as possible, as not boring as possible, because law is very boring. But you have the strategic 007 on one hand, and you have the FBI hostage negotiator, Somalian pirates on the other, right? So that depends on the lender's personality, right? So the lender is the aggressor. They could be an aggressive foe, which would mean hostage negotiation, right? Or it could be 007 and kind of like he's more teeter-totter, timid, a little bit, but timid. And he might do one of two things, the lender. He might say, look, Barney, I understand what you're going through. I'm going to give you another 6 months. Do me a big favor. Sign this pre-negotiation letter. And in that pre-negotiation letter, Barney's giving up his property. He's deferring his interest. And in the event that he defaults one more time, the property is recaptured without a judicial process. Frankly, without any notice, without any process. Now, Barney looks at this paper and he's like, listen, I can't sign this thing. But then he has the default interest on the other hand. And he's like, well, if I don't sign this, I can't negotiate and they'll charge default interest. What Barney has to realize is the culprit, and the lender, what has to realize is the lender is not the aggressor, actually, and Barney's not the prey. They're both the prey to the aggressor, which is the market. The interest rates are the aggressor. In the beginning of the session, you said that the interest rates are the weight on the bodybuilder. But what you forgot to mention is that the bodybuilder has high blood pressure, is overweight, is eating cheeseburgers, and has been gluttonous of the free money that's been entering into his mouth. So when he's picking it up, he can't even pick up this because he spent all that money. Correct? Correct. So you no longer have a bodybuilder. You have an overweight, no offense to the middle-aged man, I'm just going to say it, overaged middle man with a bald head, right? The quintessential overaged middleweight man that wants to get back into shape, and that's the economy, all right? So they can't pick it up. So the real aggressor here is the economy, and it's crushing down on both the lender and the borrower, right? And if they're crushing on the lender and on the borrower, even though the lender is charging 24% interest on his $10 million loan or $100 million loan on Barney, Barney has the ultimate leverage. What is his ultimate leverage? He can say, look, Mr. Lender, either you and I are going to take the race to the bottom and we're both going to be left with nothing because the market is teeter-tottering down, and in 24 months it's going to go back up, and I will likely, have to be forced to keep you in court to exercise my rights to the best of their ability in good faith, right? Or you can let go of my personal guarantee that I have on this property. You can give me a little slither of a carve out of $200,000, $300,000, $400,000, $500,000 for me to live another day, right? And pay back my little big birds that are knocking, and I got to take care of them. There's another lawsuit brewing there that we're going to talk about in a moment, right? Mm-hmm. And the lender is going to either have the personality of, no, I will not do that. I will skin you like a cat and fry you on a pan. And I'm going to be extremely aggressive, and I will be forever haunting you in your dreams. Or the lender could be astute and say, you know what, I understand. I get it. And what's going to make that lender say, I get it, is the lender's lender. Because the lender's lender, right, is telling the lender, I have LPs too. I gave you money. I trusted you. You went to these private equity guys and invested into Brooklyn and Manhattan and Queens and Atlanta and everybody. You used your business judgment rule not in the right way. And you did not forecast that. So the lender's attitude is dependent on how much he is holding on, right? This should be extremely, extremely relevant to you because we looked at this from the residential point of view in 2008. In 2008, They gave out so many mortgages and they needed to keep making more money that they now went below market at B and C and D. And they kept getting gluttonous and more gluttonous and more gluttonous until it just popped. Same thing here. We're just dealing with the commercial real estate market. So ergo, the concept of the LP becomes the debtor, the borrower, Barney, becomes the debtor, the landlord becomes the debtor, the sponsor becomes the debtor, the lender becomes the debtor, the lender's lender becomes the debtor. Everybody becomes a collection agency. Now everybody wants their money back. There's no more money in the market. What do you do? So you've asked me a question. You asked me a question. Leo, take me step by step. There's two tracks. The first track is aggressive. Next track is non-aggressive. Non-aggressive typically ends with a modification of either interest rate, amount to be paid, when it's to be paid, and a balloon payment. Aggressive ends up in my domain, okay, in my litigation department, not my modification department, where I'm litigating everything. And if it doesn't end at litigation and there is a judgment, right, after 3 years of fighting and the market downturn is all the while, there's like, out of $10 million, there's $100 million owed. I'm being facetious, obviously. And there's no way that the market is going to bear the asset being sold at that point. You go bankrupt. And you asked me about bankruptcy and how bankruptcy is different from a court of law.
Yeah, before you get into that quickly, so let's use your hypothetical example, right? So the borrower knows that they're going to be in a bad situation. They retain an experienced lawyer like yourself. You come in there and your goal is to buy them the most important commodity in the world, which is time. So, right? So you're trying to buy them time. You're trying to do it in a very, kind of that, very soft or aggressive way, whatever makes sense for the situation. But if yourself and, if history proves itself, we know that interest rates are going to be reduced because the Fed is paying a huge amount on their own debt right now. So that's going to be reduced. So we know the market is going to come back. We know people, over 100 million Americans live in apartments, 120 million Americans live in apartments. So we know this multifamily guy will be in a better situation as soon as the interest rates come back down. He's a good operator. Isn't the goal then for you, rather than negotiating with the lender, to just get him to that 1.5 to 2 year milestone where the prices will come back up?
I love that question. And here's the way I'm going to answer it. What is the current default rate on a piece of real estate that the lender gave? The highest could be 24%, right? Right. That's the law. Okay. If you get an attorney, do you know what the interest rate on attorney's fees is if you calculated them? 4,000% a month, 5,000% a month, 6,000% a month. Because when you're giving an attorney money to go to war, right, you need to give them a lot of money. You don't need to give them 5, 10, 15, 20,000, right? If you've set on or embarked on the fact that the market will go down and will go up more relative to or more than the amount of legal fees you will pay to defend yourself and get you to that 1.5 years, then you, my friend, have a lot of courage. And that courage, and I can say other things, right? But I said courage.
Yes.
Courage, what is the definition of courage? Courage is standing up and facing your challenges in the face of adversity. That's what courage is. So if you, as a developer, decide to face your challenges in the face of adversity, you better put your mouth where your money is, because paying interest fees at 24% has nothing on paying legal fees every single month, month after month, because rockets cost money, people cost money, legal fees cost money. And if you have one person at $400 an hour, it feels the same as having one person at $1,000 an hour, because that is money that is called bad money technically, because you don't know whether you're going to win, right? You don't know whether you're going to get there, right? So it's an analysis. And oftentimes, our clients hire an additional person. It's called a restructurist specialist. It's like a Winston Churchill, right? Who was Winston Churchill? Winston Churchill was the wartime general, He was the wartime president. And in this wartime, you can't hire the same type of general that you have when everything is quiet, because non-wartime, peacetime generals are creating infrastructure, creating budgets to create more jobs, to create tax policy, right? Wartime generals are divide and conquer with the assets that you have, conserve resources, implement strategic goals, right? So we already see that peacetime generals and wartime generals, right? And that's what we are. Attorneys are generals. You as the client, LPGP, are the president, right? But sometimes the president was a peacetime president or peacetime warrior, if you will. That person wasn't a wartime president or an individual that understood how to be in this level playing field when everything is essentially blowing up. So you really need two pieces of two people, okay? Really, if you have that big of a problem. And that would be a restructurist, and that would be an attorney that is a wartime attorney and a wartime restructurist. Of course, if you have $1 million problem versus a multi-million-dollar problem versus a $1 billion problem, we are right now, our firm is negotiating at least $500 million to $1 billion in debt and in equity. We've seen it all. Okay, we understand the process, and I hopefully answered your question about, can I wait a year and a half? The short answer is, can you wait a year and a half?
The costs, the litigation costs and other costs might not be worth it, because it's just better to negotiate and get a deal made. But talk to us about you were getting into bankruptcy, and which bankruptcy as a strategy to buy time, I believe, and differentiating with personal bankruptcies.
Looking forward to learning more about this.
So bankruptcy is a court of equity first and foremost. That's a very fancy way of saying, Leo, under my contract, I have zero defenses. I'm cut from the head. I have zero defenses. To whom can I go? Which wicked witch can I visit, right? Or what yellow brick road do I go on to find that person that understands me, that understands that the value that I hold, irrespective of the defenses that I have, can protect me? That's a bankruptcy court, because a bankruptcy court says, okay, Mr. Borrower, you've lost all of your money and you have $2 to your name. These lenders and creditors over here, Exhibit A through 15, want to cut your head off and kill you and sell you to the dogs, or put you in debtor's jail, which no longer exists in the United States. It used to exist. Still exists in China. That's why people always pay their bills, okay? In China, as I've heard. But here, they don't always pay their bills. And when you go to the bankruptcy court, you have what's called a process, an organizational process. If it is a single asset real estate company, which is basically, it has a specific definition for our purposes, multifamily would be, condos would be, rentals would be, portion or parcel would be, they give you 90 days to file an exclusive plan of reorganization, and then an extension of another 90 days to file an exclusive reorganization. But if you have a very aggressive lender, the lender is going to want to get into bankruptcy and say there is no reorganizational purpose. They've tried for many, many months to obtain financing. They cannot maintain financing. It should go into our control and we should sell it. There are two reasons you don't want to sell outside of a bankruptcy court. Number one, it's not a controlled process. Number two, you are not controlling the process. If you are subject to a foreclosure sale or a UCC sale, which is sale of shares, which are volatile, although they're attached to real estate, okay, they may sell for very, very less because they were not marketed properly. And because they were failed to be marketed properly, the value of your deficiency is much greater. So you want to go into bankruptcy court to at least be in control of the sales process, to get the best and the brightest price for your piece of real estate. Why? So at least you can close the gap on your deficiency.
Mm.
Also, there are equitable principles that you can take advantage of, not in all cases, in some cases, that can wipe out the default interest, right? So say, for example, for 2 years, it would be a default interest. You can ask the judge to only charge the non-default interest or wipe away the default itself. So that happens in rare circumstances, but can sometimes occur. I'm giving you huge brushstrokes about why there are benefits to bankruptcy. When you do file for bankruptcy, and here is a question that nobody has ever asked me, I'm going to ask myself and I'm going to answer myself. You've asked me a very specific question, which is, Leo, does bankruptcy hurt if you're filing from an LLC? Does it hurt the person personally? Your nod was that it does not. Factually, you were correct. It does not. But this is what the audience wants to hear.
It's a Trump thing, right? Trump has filed for bankruptcy.
I'll explain to you. When you file for bankruptcy, any further applications for credit as a corporate person will be seen as a B minus C plus bond. So the interest rates will be higher, or as a borrower who went corporately bankruptcy on a corporate, not personal level, corporate level, now has to disclose that. And the interest rates may be higher, and that person may no longer be funded. That is what your audience is probably afraid of. Their intuition is telling them, okay, yes, personal bankruptcy, I'm not going to be personally bankrupt. I understand it's not going to personally affect me, but it is going to affect me when I'm filling out another application, and it's going to say, has your corporation ever went bankrupt or any of your affiliates went bankrupt? And the answer is yes, and that changes the terrain. So you're going to say, Leo, so you should never file for bankruptcy. No. In order to consider whether to file for bankruptcy, there's many reasons, but amongst those most important reasons is, do I want to live another day as a corporation, okay, and invest through others for a bit of time, right? Or do I want to strategically place bankruptcy in a way that changes the money I owe somebody, which might be debt, and turn it into equity, okay? And you can sometimes do that in bankruptcy, where if you take a loan from somebody, okay, you can recharacterize that loan into equity. What is the value of that? Because debt sits at the top. Equity sits at the bottom. So if you want to maintain your leverage against somebody that you don't like, that you hate, that has a gun to your head, I'm showing a gun to the head, right, like that, right? You want to say, hey, back up, or I'm going to force to change the complexion of what I owe you into equity and drop you down into change what you owe me in debt and drop you down into equity. I'm going to change the complexion of the relationship between you and I, irrespective of the contract that we have. Because bankruptcy is a court of equity. Equity is a court of fairness. Fairness doesn't always look at contract law.
So Leo, let me ask you something. Can in a situation where a syndicator, a sponsor, a developer is trying to just buy some time, they have an equity partner coming in, or a certain milestone is coming along the way, and they need to just buy themselves 6 months, let's say, could a bankruptcy like a process be used just to keep the lender at bay, but not follow through with, and just not go through it, just use it as a ploy?
The answer is maybe. So when a client comes to the door, okay, they often do not know what to do. What they're doing is they're going to an attorney that is not a counselor. They're going to an attorney that is an advocate. And the advocate's like, yeah, we got to fight. Don't worry, we're going to fight. No. When a person comes to our office, we check his pulse, figure out his blood pressure, right? Is he breathing? Is he walking? Is he understanding what he's doing? If they are not, he or she is not, we say, what is your objective? And oftentimes the objective is, I just want to save myself. I want to save myself. I want to save this property. I just need a little bit of time. They don't understand their actual objective. What they're looking for is they're looking to ground themselves. They're looking to sit on footing that they can step on, right? So when you're asking me the question, Leo, you know, can someone as an investor use bankruptcy to gain time? The answer is maybe, right? But oftentimes that's not the objective. The objective could be done differently, not through bankruptcy, right? It could be done through a position letter that describes and annotates that bankruptcy can come, that these are the consequences for both of us, right? So you're asking, Leo, if I put I don't want to say threat. We can't threaten as attorneys, right? We would never want to do that. We would never want to just go bankrupt just to obtain time. The value of going bankrupt is to have a reorganizational purpose. It's to tell the judge, Your Honor, I need this much time to reinvigorate my business plan. And the judge says, okay, he or she is sincere. He or she has a plan. He or she has a timeline. He or she has professionals. So when somebody comes into my office, of course the objective is to get time. Of course the objective is to do those things, but it's to do those things in good faith. Because one thing that attorneys do not like and hate most of all is when they're wearing the face of their clients' objectives and communicating it to the judge ineffectually, disingenuously, and not meaning what they said. So to those individuals that want to get more time, it's a very complicated answer. The answer is of course, but it has to be done in good faith.
Got it.
Right.
Got it. So let's discuss now. You talk about borrowers. You talk about putting up your house, putting up your car, putting up, coming after your personal assets. And in our space, we're dealing with tens of millions of dollars. We're dealing with tens of millions of dollars in assets, right? In some cases, even hundreds of millions of dollars of assets. At times, especially newer groups or boutique groups, it's difficult for them to debt service those types of loans, and they bring on loan guarantors, or they bring on, in our space we call it a key principal, somebody who's going to come on, sign off on the loan, and they get a piece of the GP stake or what have you. Talk to us about a situation where a hypothetical where somebody's putting a deal together. Let's hypothetically say it's a real estate deal, and they bring on someone else to sign off on the loan. So you have a loan guarantor involved. What happens in a case of default when there's a loan guarantor involved? Does the general partners go under the microscope as well and get into issues as well, or not? Talk to us about that situation.
So there is a loan guarantor that is guaranteeing the loan. The guarantor's rights are separate and apart from the debtor's rights, okay? The guarantor has limited rights, but guarantees all of those rights and obligations of the debtor. That's problematic. So the guarantor is the queen, and the debtor is the king. You kill the king, you probably already killed the queen. You understand? But if you have the queen at play, which is the most valuable player, which is the guarantor, if the queen loses its value, right, the assets around the queen that the queen owns are not enough to pay the liabilities of the king, guess what happens? The lender comes up to the queen and says, give me a little bit of what you have and I'll let you off of the guarantee. Oftentimes, what the queen is doing is hiding from the lenders. The queen should be upfront in the lenders, saying, look, my assets are not enough to pay my debts.
What if it's a non-recourse loan that their debts from day one were not supposed to be on the table?
Right. They weren't. But when you're signing a loan guarantee, what they will do after summary judgment of the debtor, because the debtor usually fails to pay, they move for a summary judgment, which is a summary proceeding without a jury. It's a judicial proceeding on paper that basically says, we will win. We will win. And the lender wins. And once the lender wins, they freeze all the assets of the guarantor, which in our scenario is the queen. Okay? And once they do that, the queen can't move her assets. But if the queen can prove through accountants and consultants and attorneys that the value of her assets are not enough to pay the debtor's liabilities, well, you can't get blood out of a stone now, can you? So the maneuver is not to hide and show a shadow. The maneuver is to show yourself as you are. There's beauty in being ugly. Does that make sense?
Somewhat. We still want to kind of, Ava, as far as non-recourse, recourse.
Yeah, I wanted to actually, not recourse versus non-recourse, right? But
so recourse versus not.
But one thing I'm kind of learning here, and I want if you could break this down for me, is non-recourse. It kind of is still recourse in some ways. Like
it could be turned. It could be turned into recourse.
There are non-recourses. Asset is the only place you're looking to take from. Recourse is I'm looking to take from the asset and from the queen, right? Right. So non-recourse is just the king. Recourse is the king and the queen. Make sense so far?
Yep.
Yeah.
So there are what's called springing guarantees, partial guarantees, contingent guarantees. There's all types of guarantees. So before the guarantor, who is in utmost need, wants to prove himself, to his mother, to his fathers, to his investors, is going to want to sign that document and say, look at the beautiful Williamsburg hotel that I have, or the Atlanta football field I got. But they've placed them to themselves to the hilt, and they're popping champagne. But then COVID happens, interest rates go up, rent laws change, and you're in a very painful place in your life. So understanding the rights and the obligations and responsibilities of the guarantor are excruciatingly important as they relate to the debtor. And I can understand somebody's motivations listening to this to say, Leo's crazy to think that I'm not going to sign that personal guarantee. No. Sign that personal guarantee. But just listen to this podcast, if you will, and understand the consequences of it. Right? It's being educated and appraising yourself of the consequences that doesn't feel so painful when you know about them. It's like getting a shot in the doctor's office. You kind of pulling away and you close your eyes and like, no, don't worry. Look, it's not going to hurt. And they're like, oh, when are you going to do it? It's like, I already did it. So that's kind of what you want, the expectation. Building expectation for a guarantor, building expectation for the debtor is exceptionally important. What you don't want to do is not shell out money to your attorneys, consultants, and advisors. You need to have a board of directors when making decisions on behalf of others. If you're using OPM, other people's money, you have to have other people to tell you what to do about other people's money. It's all about delegating responsibility, and it's also about delegating liability. Those are the quintessential facets of being an excellent CEO, CFO, COO. Education is not like others would say to prove that you can get a Lamborghini and can get a big house and get all these things. Education is something that builds confidence inside you, that when the pain comes, you can keep it there and you don't crush under it, right? That's the best way I can describe it.
No, nice. Beautifully said. Here, let's go over this.
Okay, I want to quickly quote somebody. His name's Leo Jacobs, and he says, for every dollar spent on litigation, you get back 10 cents. For every dollar spent on mediation, you get back $5. Leo, can you explain this to us?
Of course.
Perfect.
Litigation is the annihilation of someone's resources to obtain leverage against that person, okay? And that is litigation. So the return might be that you've destroyed somebody's resources, but they've destroyed your resources 5 times. And it's agony because you have to rebuild. Mediation is when you stop fighting and stop destroying each other's resources, and you build consensus by perceptively organizing in the other's side what can happen if you continue to fight. So the investment of litigation, although you may have a very powerful position, hands down, 100%, remember, there are collateral consequences to winning a fight. Somebody might burn your house down. Someone might sue you. So, there could be other things that occur. Don't think that in the land of the invincible that you are invincible, okay? Because the only one that becomes invincible is the one that is the last standing. And the one that is last standing has to recreate everybody because he can't do everything or she can't do everything, right? So that is very, very important. You're not going to burn the forest down to cut down one tree or burn one tree. That is what I mean, that when you litigate, although we love litigating, by the way, that's a lot of money for our lawyers, okay? It's a lot of money, and we love that. But mediation is maybe half of that, still expensive, but it's in preparation to build consensus. What do businessmen want to do? They want to never, ever give $1 to an attorney that they do not have to an accountant that they don't have to an advisor that they don't have to. We are a cost center. We're the most expensive friends you will ever have, okay?
So lawyers can do mediation as well?
Of course.
And if you have a disagreement with someone else, is it better to start litigation and then mediate, or to start mediating right away?
Excellent question. To all the transactional attorneys out there, please put into your operating agreements to have, as a matter of contract, the right to call a mediation on substantive and non-substantive matters. What are substantive matters? Let's use a building. Structural integrity of the building, changing plans, changing CFO. That has to be mediated, contracted for. If there's no mediation, privately arbitrated. If there's no arbitration goes horribly, then you go litigate. Never do you want to have a public figure, have a public fight about something so menial, right? Only reserve to go to court if you need to have interim relief. Somebody's embezzling money. Somebody's stealing something. There's a fraud going on. The government needs to burn down your building because there's a rat infestation. You need interim relief so they don't burn it down, so you lose your investment, right? All of this requires attorneys' times to think. Now, who the hell wants to pay $1,000 an hour on a blended rate to pay an attorney like myself or my members to get those things done? Here's what I'm going to say to all those individuals that want to save money, okay? Borrow it. Because if you borrow $10,000 to pay your lawyer to draft a nice operating agreement, or 15 or 20 or 50, it will save you hundreds of thousands of dollars that you don't want to lose.
Very nice.
Rather pay 10% interest on that money you borrowed from your cousin to get a good operating agreement than not do it at all. Mm-hmm. There's going to be 100% of people that hear this, and 99% of them say, I don't care enough to do that, right? But we have to educate the folks out there.
Absolutely.
And it's only an opinion of mine. There's a gazillion opinions. There's tremendous amount of motivation for lawyers to bill. We love billing. That's how we make our money. But we want to do it in a positive and an impactful way. That does not translate to cheap and fast. That translates to expensive and good, right?
Yes.
But not everybody wants Chanel. Not everybody, wants, Prada. They sometimes want Payless or they want Nike, right?
Yes.
It's up to them. It's up to them.
You get what you pay for. But before going into the next segment of our show, last question that we have here for you, and this is, we talk about opinion. This is more opinion driven. But, we were watching a show that you had, a podcast you had with Jacob Friedman. And, Jacob was using this analogy of where we are at currently in the market, in the real estate market. And he was using an analogy of a clock, and at 12 o'clock being the top of the market, 6 o'clock being the bottom of the market. And you guys had this great discussion about what each one of you believe where we are at within that clock. Are we at, 3 o'clock, 1 o'clock, 5 o'clock, where we're at? So I'm going to pose a question to you and ask you, where do you believe we're at, and kind of give some context to it?
Please. Yeah.
That was in August. August, where I was thinking about like 6 or 7 o'clock. That would be the bottom of the market. And that's where the opportunities will show for well-heeled investors to begin to buy distress. Yeah. I now think we're even further into that market now, even without any liquidity in the market. I believe we're in recession. It just hasn't been announced yet. I think they're waiting for January to come in after everybody comes from the holidays to January 20th to 24th to say, hey, guys, sorry, we're in a recession. We might even pick up interest rates more. And then everybody's going to go bankrupt one by one, because they're like, okay, no more money. They're not extending the SBA 7A program. They're not extending the EIDL modifications. They're going to raise everything up to $10,000 a month again for all those people that took out $2 million. And there's like thousands and thousands of people that took out $2 million, and they can't operate anymore. So we're at the bottom of we're between like 7:30, I think, 8 o'clock. No, 6:30, 7 o'clock. We're really at the bottom, and now the distress is really showing. That basically means the opportunities now for well-heeled investors is growing, and the bankruptcies will be growing, right?
But hold on a second. We can't be past 6 o'clock if you believe there's more distress and there's more pain coming, because 6 o'clock, it was the bottom of the market with the price, not sentiment.
I agree. So I'll change my clock. I think it'll be like, it's 5:30 right now. Okay. I'll say it's 5:30, and 7 o'clock. 7 o'clock is probably going to be first quarter beginning, or first quarter ending. We're going to be at 7.
Okay, I'm going to do a LinkedIn poll, and I'm going to tag you on there. So just watch for that coming. But we'll see what others say. But keep going.
And by the way, I'd like to mention WeWork, if I may. Can I mention something about WeWork? If I may?
Of course.
So WeWork is going bankrupt next week. Okay, that means a world of things. It means a world of things. And one of the most important things that it means is that the B and the C buildings that have housed WeWork in order to refinance their buildings no longer have an asset that was at least 40% of their capital stack. That means a tremendous amount of B and C and maybe even A buildings are either going to go bankrupt, have to reamortize, look at equity to take on more debt. And that is not going to be surprising in this market in January and February and March. So if you are a WeWork building or someone that is housing WeWork and WeWork is going bankrupt next week, you need to exercise your defensive rights when they decline, they either affirm or disaffirm in bankruptcy court your lease. Because if they affirm your lease, they can pay as they are. If they disaffirm their lease, meaning they reject the lease, they have to pay that landlord 15% of the remaining amount left on the lease, or 1 year's worth of the value of the 1 year of the lease, whichever is greater. Okay? So you need someone, an aggressive counsel, because you are now the debtor and the creditor almost, right? Because you're owed money, you want to get money, and you need an attorney that is sophisticated enough, right, and malleable enough to discuss with WeWork what they want to do. Ultimately, they want to get into agreements with people, and they want to do it through the consensual process of a bankruptcy, because they will come out leaner and meaner. WeWork is the metaphor. Just a moment. This is the metaphor of the New Yorker, the New York fat person that's overweight and needs to get skinnier. And that's what WeWork needs to do. WeWork needs to get onto Ozempic, okay?
You think it's going to survive after its bankruptcy?
Yes. It'll be leaner and meaner. It'll be leaner and meaner, and it will survive, and it will be WeWork light. That's what it will be. And WeWork has proven its concept. They just got really, really fat with free money and need to get on a treadmill and get a little bit skinnier and have some fruits and vegetables.
All right, maybe we should do another podcast just on WeWork alone, but that's interesting. Okay, great. Let's get to the next segment of our show. Get these questions out of here. Thank you so much for all your wisdom and knowledge that you shared with us.
Yeah, Leo.
Keep in mind, Leo is $1,000 an hour, so we just saved.
I was just going to say, yeah, absolutely. This is great. All right, how long can we have you for today?
Go ahead.
All right, okay. Next segment of our show, Leo, the 10 championship rounds to financial freedom. Are you ready?
Yes.
Whatever comes top of mind. Here we go. Here's the first question, okay? Who's been the most influential person in your life?
My father and Winston Churchill. If you'd like me to explain, I'm happy to explain. If not, those are the two people.
I would love for you to explain.
Explain.
So Winston Churchill is the definition in my mind of courage. Staying ahead and facing your challenges in the face of adversity. And my father, because he has provided and instilled the confidence and the plight of humankind and human decency in my heart. And my mother for compassion. Obviously, she is not second. She is one and the same with my father. So
beautiful.
All right, next question, Leo. What is the number one book you'd recommend?
Oh, wow. Probably Ray Dalio's book. I forgot what its name. Oh, the Daily Habits and Principles by Ray Dalio. An exceptional book. And if you're a manager in a big company, Paid to Think. It's a yellow big book. Paid to Think. It's an organizational book. Excellent book. I read it multiple times over, and I have been able to grow from one person to a full administrative and collegial staff in a very short amount of time.
Amazing. Incredible. Thank you for that. Okay, next question. If you had the opportunity to travel back in time, what advice would you give your younger self?
Oh my God. I've often confused impatience for not knowing something. And I would tell myself that my impatience is actually my calling, because I've oftentimes confused that for a little bit of anxiety. So those that are struggling with anxiety and that impatience of what's going to happen in the future, think of it as your calling instead of, oh my God, I don't know what's going to happen to me. And I think that was extremely impactful in my ability to get ahead and to say, wherever it is that I'm going, could be cold, could be hot, could be miserable, could be scary. That is my calling, and I have to, carry it through. So that's what I would say.
Nice. Okay, next question. What's the best investment you've ever made?
That will be in my children, in my wife, in myself, and in the belief that there is a higher power. I don't know, what some people call it God, some people call it energy, some people call it giraffe with marshmallows on them, but whatever it is that you call it, that investment is greatest. It's in your children, it's in your loved one, if you have a loved one in your place, it's in yourself, and it's in the higher power, and it's in the people that you love, of course.
Beautiful. Amazing. Love it. Okay, now what's the worst investment you've ever made, and what lessons did you learn from it?
The worst investment I have made is in people's promises that can't keep their promises. And that is exceptionally true when you're picking your team. Oftentimes people over-promise and underperform. So your investment into people is an investment in yourself, and make sure that people can stay true to their promises. So the worst investment I have made are in those people that have overpromised and underdelivered. Expectations not aligned with them, and I am exceptionally critical about how far someone can throw the ball, and I ask the right questions to do that, to never make those mistakes again.
Nice.
Hire slow, fire fast.
Hire slow, fire fast. That's right. Okay, next question, Leo. How much would you need in the bank to retire today? What's your number?
So that number is related to an investment that I am going to make into my ultimate goal. And I tied it to my ultimate goal. My ultimate goal is to build schools for children and educational, secular or non-secular, whatever, for children. I believe that children are our future. So I will retire from making money when I have something inside of me that says, Leo, you've fulfilled your purpose in life. And my purpose in life is not to build the biggest and brightest and baddest bankruptcy and commercial litigation firm, which I will, and I am. But it is the most of me that wishes that my true goal is to build schools for children in education, and after school programs for mothers and fathers and those people that can't take care of their children. So
can we quickly put a number on that? How many schools, how many children are going to be educated from your schools that?
Of course. So we have 50 states, one in each state, and we have 7 continents. So a school in each continent.
Amazing.
So
there you go. There's your goal, brother.
Beautiful.
We just came up with it together. All right.
Wonderful. Okay, next question. If you could have dinner with someone dead or alive, who would it be?
Well, of course, Winston Churchill, okay, because I am a wartime general and I consider myself a president of my own cabinet and my people. Person that is alive. Person that is alive. I have a very good person, so I want to get his name. It'll probably be Schwartz of Blackstone. I want to,
Stephen Schwartz.
I want to meet him and I want to talk to him because he has the pillars. He has the pillars that mount a successful firm. In a very short amount of time, he's become a great man. Irrespective of his political, religious ideologies, I think he's an exceptional man, and I look up to him in that regard.
Yes, amazing.
Nice. Okay,
cool.
Awesome. Next question: if you weren't doing what you're doing today, what would you be doing now?
Somewhere in a nonprofit for children education. That's what I would be at if I had all the money in the world.
Yeah, nice. Okay, my favorite question, Leo: book smarts or street smarts?
Of course, both. Street smarts gets you to the client. Book smarts keeps the client. Okay, so street smarts gets the client. Book smart keeps the client. Nobody has ever said that. I say that all the time. You like that? Yeah, I see you like
that. Love that.
Okay. Hustle, the client, guys. The hustle gets the client. Hail or high water, you got to get the client. That's hustle. That's street smarts. Like, hey, what's up, Joe? How you doing? Give me Nancy. Give me Lou. Get me to the bar. I'll be outside 12 o'clock. It's raining. It's snowing. And the book smarts keeps the client, right? You do good service. You do good work. That's what keeps the client. So street smart and book smart.
Cool.
Amazing. Last question, Leo, okay? If you had $1 million in cash and you had to make one investment today, what would it be?
It'll probably be in a children's school that I would give it to, probably into my son's school, and I won't say anything else. It'll be in my son's school and my daughter's future, where she's at. That's what I would do.
All right, amazing.
Incredible.
Thank you so much for your time. We really appreciate it. Thanks for taking the time being with us. And
last thing is just maybe let the audience know what's the best way that they can reach you, Leo.
The best way is you can email me at leo@jacobspc, JACOB as in boy, SPC.com. Now, that is the best way to reach me. I don't necessarily give out my number just because I'm always inundated with phone calls. And that email goes directly to 3 of my administrators. So you will get an email or a phone call back right away to schedule a meeting with me. We unfortunately do charge for consultations, but the business that we're in, I think we have to. I think the information here should serve as a benchmark of what type of acumen you can see from a Jacobs PC member. I am the CEO. I wish everybody the best of luck in this, tyranny of what is about to happen, in my view. And hopefully everyone can come out on the better side of it. And I wanted to thank the both of you for having a tremendous ballot of questions to ask me, so I can give you some very, very good answers. And hopefully I've impacted enough that people will, or I've impressed upon enough that, there's something to think about and something to look forward to.
Absolutely. Thanks so much again, Leo.
Thank you. Bye, guys. Bye. Thank you so much.
Thank you for joining us for this episode. We hope this conversation enlightened you on how to win big in this highly profitable and risk-averse space. Get on your feet and embrace this world that offers so many opportunities just waiting for you out there. Continue your journey to becoming a savvy real estate expert by subscribing to the show at cpicapital.ca. Don't forget to leave a positive rating and share with your friends. See you on the next one.